an executive chairperson. That we have learnt much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions, or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the IBC. The verification has to be done by the IBC. The declaration decision has to be made by the IBC. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki, in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, in great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor. No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity. No, there was not. And it is very important to realize that we do not use these exaggerated criteria in order to come to a justification of plain wrong. The issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, Unilateral Declaration of Independence, to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still recognize the usurpation of power. And they were hung, not only in Rhodesia, but in Pakistan. After a coup, their courts accepted that the doctrine of necessity, the acknowledgement of what was shown to be the new Grundnorm, would have to be acknowledged. And so, the coup was all right. And so, my learned friend, the professor, is saying, you too must acknowledge. And what does the doctrine of necessity always acknowledge? It acknowledges wrongful taking of power. And the Grundnorm is thereby changed, and therefore the court must accept it. So they're basically saying to you, recognize there was need, recognize that the chairperson did this out of necessity, and therefore it has to be accepted. It was done in Nazi Germany. That's where the Grundnorm comes from. And therefore, we submit not only that you should reject it, but you should condemn the attempted use of it so that it can be used here now in this innocuous, apparently innocuous moment in a case in a hall full of lawyers and judges. But it is a very dangerous thing, not only historically, but because Professor Kindiki revealed, perhaps unknowingly, that we now know that the doctrine of necessity has been discussed in their private thinking and now is brought here publicly. And when there is, next time, there doesn't have to be a chair and 3 people and 2 policemen clearing the chaos. Next time, when there is a manufactured group assaulting another group of 50, 100, 200 people, who will get up and say, we have taken power as an act of necessity? Because our attempt to do so at Bomas, to establish a new government not in compliance with the Constitution, failed, as it should fail. But now, with the doctrine of necessity, we are there. And we will take on anybody who says that we are doing anything wrong, because the doctrine of necessity requires that we restore peace and order and move on. And then when we bring the matter to court, learned Professor Kindiki will be here to say, I will now refer to the case of Mandus Budiro, South Rhodesian law reports, and say, here it is. Here is Pakistan. Here is the case from Uganda after the Uganda coup, applying the same thing. And we say, this is the prophecy that is put forward now in their thinking, shown unwittingly, I think, by Professor Kindiki, and placed before the people of Kenya. We say, not only reject it, but reject it consciously, so that the precedent is not of a submission which failed, but a precedent of the Supreme Court of our land rejecting this ever for use in Kenya. So what should we be using? I'm happy to say that, again, from the respondent's side, I draw some inspiration. And that is from my learned friend, Senior Counsel Fred Gatia. My learned friend, both learned and friend, put forward before the court, and he said, let us get at the substantive truth. He put forward a criteria completely different from Professor Kindiki. And I'm happy to say, yes, let's do that. So we put to you, when we put forward the manipulated postponement of Mombasa and Kakamega, we showed to the court that the Gazette notice, the power which Mr. Chabukati used, was illegal because in the Gazette notice he lied and put forward just half of what the power he has needs to meet. And so, when we put these forward, they could not reply, but those who attempted the reply said, but look at this. This is his power, this is his section here, and he's an executive, he's this. But Senior Counsel Gatia's principle was a more important and relevant approach. So we say, what is the substantive truth behind the postponement, behind the lying Gazette notice, before the self-serving amendment of the Regulation 67, by which he changed, this chairperson changed, or got changed, the constitutional provision that the papers 34A and B received at Bomas must be dealt with by the IBC Commission. Instead, he changed it to the returning officer. It has been pointed out there is no such office, and he put it there. What is the substantive truth behind this? What is the substantive truth behind the fact that despite several orders from you, the server has not been fully opened? What is the substantive truth behind the fact that this is not the first time this chairperson has disobeyed the court? What is the substantive truth of the absence from his behavior of any reference to Article 10? Article 10 is values. They are national values. And the beauty of our Constitution is that it is not only a manual of government. Finance will be dealt with this way, so-and-so will be appointed that way, he can resign or he has to be removed or this or that. Each and every chapter has its specific values set out therein. 81, 86, and at no point in the whole of the day spent and today, this morning, has there been any reference by the ballot paper, how did we advance Article 10? There is even one more duty on them, on the chairperson. It is that it is part of the duty of the chairperson, the whole commission, to ensure the removal of any impediments to the functioning and the purpose and the aims of the commission. They have breached even that, even the passive duty. And we say, yes, that is what we look at, the substantive truth of all these things. And in that, once you do this, it is clear that this is an election which is brazenly, shamefacedly, without remorse, saying we did right when we were doing wrong. You do what you can about it. Nothing happened to me in 2017 personally. And it is all right. We say no, and we say to the court that not only is the petition, we pray, to succeed, but very importantly, if you find that there is violation of the Constitution by the chairperson, it is not necessary for the court to take any steps to his removal. There is a constitutional position. Thank you. There is a constitutional process to remove him, and there is no need for the court. But there is an important duty on the court that if you find a serious violation, and we submit there are all these serious violations, it is important that the court makes a finding. We hold that, or we find that the chairperson violated this article or that value, and that those are set out. We pray accordingly. Thank you.
Having just come in, good morning, your ladyships and my lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend, again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the IEBC. I, at that point, did ask whether he's an employee of the IEBC, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the IEBC. And we would request that millions of public money not be used to do this. But the programs that exist for editing a PDF document include Adobe Acrobat DC, Foxit PDF Editor, PDF Filler by AirSlate, PDF Element, Small PDF, Nitro PDF Productivity, Fine Reader PDF for Windows and Mac, Adobe PDF Pack. And I would also invite the court perhaps to try any one of them out. Staging, I just want to add that staging is admitted even by IEBC. So it's not, does not lie in the mouth of counsel, belatedly briefed to deny that there was such a facility. Mr. Maina Wachira Nyaga, paragraph 2 of his affidavit, sworn and filed on 29th August 2022, confirms there was a middleware in the results transmission system. And this is also confirmed by one of our IT experts, Mr. Benson Wesonga, that there was indeed an attack from the position of man in the middle. At page the evidence we produced of the data analysis by George Njoroge in his affidavit sworn on 28th August 2022 and filed on the same day, pages 68-73 of his report, Mr. Njoroge says that the results from the the results from the polling station was between the 9th and 14th of August tallied 137,000 times 137,847 times. On the 9th of August, 38,353. On the 10th, 35,000 times, 574. 11th, 16,291. 12th, 8,357. 13th August, 14,357. 4th August, 24,000 times, 897. This shows that numbers, the same numbers were being brought back into the system from 34s, new 34s. Otherwise, and trying to find the magic number that would give the first respondent the win. Finally, I would like to make a few comments on the just concluded exercise, the scrutiny exercise, and state that very shortly that despite the good intentions of the court, the servers were not opened. Unless, of course, there will be another opportunity for us to make a few comments. They will? Or then?
Stop any conversation about the report at this stage.
Okay.
We will allow you time to deal with the report.
Okay. I want to say that the evidence that has been presented by the petitioners shows a well-orchestrated and fraudulent scheme that was executed with military precision. Let me agree with my learned friend, Mr. Mahat, on the use of the word military. He says military grade, but I differ with him to say the rigging was executed with military precision, and given the evidence that has been availed, using expert, foreign, and I'm now using another military word, mercenaries engaged for that purpose. I am not surprised that none of those gentlemen I'm referring to as mercenaries have not sworn an affidavit. People like that disappear and leave the country to its own devices. By the grace of God, we have remained peaceful, and I pray that we continue to do so. And finally, I will yield the floor to my learned senior, Mr. James Ray.
Milady, Madam Chief Justice, we would like a clarification from the court whether the replies and responses relate to questions of law that have arisen from our presentation, or whether it is an opportunity for our learned colleagues to rehash their case afresh and to introduce new evidence.
We know what constitutes a rejoinder. It's a response to issues of law arising from the respondent's response. So just to remind Council, it was about responding to matters of law.
Madam Chief Justice, I also rise to take or to request a clarification. The court was treated to a so-called live demonstration. Shall we be given an opportunity? We don't require more than 3 or 4 minutes to indicate that what the court was shown is not true. Because otherwise, this image is now all over the country, a sensational image about forms with names of people, whereas in truth, that is not correct. All that I would request, Madam Chief Justice, is an opportunity for rebuttal. On the basis that that is new evidence, it was never played, those are not polling stations in the petition, it's totally new. It will be unfair for us to walk away without being given an opportunity to defend ourselves.
Unless the court walks away from the questions that the court asked, you asked for a demonstration of how the staging was done. It was a specific question. And similar questions were asked to our friends to the left. A lot of new material was brought in. We kept quiet because we knew these were questions from the court and that no evidence should be kept away from the court in the search for truth. Much obliged.
what we are doing, and then at the end of it, we'll consider, because we are also checking whether that is new evidence. Yes.
I thank you. I begin by thanking the court for giving me this opportunity to make my remarks as part of the rejoinder for the petitioner. My lords, when I used to be at Alliance High School, every year, Professor Gidhu is very happy about me mentioning his school. When I used to be at Alliance High School, every year I took part in a school play. Most of the time they were Shakespearean plays. Macbeth, Julius Caesar, Much Ado About Nothing. Can I recover my 4 seconds? Yes, I was saying I acted in every school play for 6 years. And when I became a practitioner of law, I tended to have the habit, every time I would appear in court, to take some verse from those Shakespearean plays, be it a comedy or a tragedy. And one time, S.M. Otieno, from whom I learned a lot as a young man in the practice of criminal law, he told me when I took my seat, "Did you read the charge? Did you look at the statements? Did you analyze the elements or the ingredients of the offense?" Always remember, as a lawyer, that oration is not good enough. Substance counts when you appear before the court of law. And I'm saying this because in 2017, when he had a similar petition before your lordships, some of the advocates who are in that petition, acting for the respondents when we presented our petition, said that what we presented before the court was a science fiction. And I'm not surprised that even at the beginning, and it's well covered in the media, that what we have presented before you is fiction. And because it is fiction, you had a lot of speeches which I think do not belong to a courtroom. They probably should have been delivered in some theater where people love poetry, like my learned friend, Professor Gidhu Muigai, whom I know, having attended the same school as I did. We share a lot of things in common. We have presented before your lordships a petition based on averments which are contained in the petition. We have placed evidence before your lordships, and the petitioners did not ask the petition to be struck out. Instead, they filed volumes and volumes of affidavit evidence, and I've addressed you at length on matters relating to the petition. And yesterday, I remember when your lordships and my ladies asked questions to the respondents, my learned friend, Mr. Gidhu Muigai, said those questions were difficult questions, but they are not as difficult as the questions which were directed against the petitioner. But having said that, there is an important point about this new constitution. And I'm so happy that your lordships and your ladyships, some members of this court were part of the process of drafting this constitution. And my lady Justice Njoki asked a question which was very pointed. Why did we create these commissions? Why did we create these independent offices and secure their tenure in the Constitution? And the answer is that we are dealing with an imperial executive. The commissions became an insurance policy for the protection of the sovereignty of the people. And if you look at Article 249, the commissions and independent offices are required to protect the sovereignty of the people. And what better tool to use in order to protect the sovereignty of the people than to have fair and free elections conducted by an independent body. And this constitution requires that the elections must be transparent and they must be administered in a neutral, efficient, accurate, and accountable manner. I would have hoped that if the Electoral Commission was indeed carrying out an election that was free and fair, transparent, and accountable, they would be offering all the evidence, including what is in the servers, that this is what went on, this is the record, this is the return of the elections that were held on the 9th of August, 2022. I thought that we were making progress. Your lordships and my ladies, there was a time that we used to file petitions against even the President of the Republic of Kenya under the old constitution. And if you approach the Electoral Commission before you file the petition, you had access to election documents and election materials before filing the petition. And I did that so many times. My other friend Firoz Norji would tell you, because I was a petitioner. And he filed such a petition. Now, to get information from the Electoral Commission, even after filing a petition and an election has been conducted, is like the road to hell. Because that's what it is. And in Article 249, the sovereign, who is the people of Kenya, require of the Electoral Commission as a state organ to secure the observance of democratic values and principles and promote constitutionalism, not just in the conduct of the elections, but even the way it runs its affairs. They cannot pretend that they're conducting elections and valuing and securing the principles of democracy as contained in Article 10 of the Constitution, and yet within the body itself, they don't value these principles that are not discretionary. They are, every state organ, every person is required to act in accordance with Article 10. What does the chairperson of the Electoral Commission do in the circumstances, not only of this case, but even in previous occasions? In the Electoral Commission, instead of having a commission of 7 commissioners, and you have seen the factionalism here, you have a triumvirate, you have a trioca that is moving together all the time with the secretary of the commission. This is not what the Constitution desired or contemplated. If you look at Article 88 of the Constitution, the mandate of the Commission in relation to the supervision of elections and referenda, at the end of that Article 88, and I think this is important, Sub-Article 5, the Commission shall exercise the powers and perform its function in accordance with this Constitution and national legislation. So that where the chairperson comes before you and does not show conduct that is in consonance with the Constitution, is that a matter that this court can just gloss over? When the Constitution says in Article 2 that this Constitution is the supreme law of the Republic and binds all persons and all state organs, and no person may claim or exercise state authority except as authorized under this Constitution. And throughout that Article 88, the Constitution throughout talks about the Commission, except in two instances, one of them being the declaration of the results in a presidential election. So I urge my ladies and my lords that where there's been an infringement of the Constitution, however good the outcome, but there has been an infringement of the Constitution, because the Constitution says how we should conduct elections. It does not matter whether you get 10 million votes or 20 billion votes. If you get it by murder and killing people, if you get it by falsifying documents, however the numbers you end up getting in an election, that would not be the kind of election contemplated under Article 81 of the Constitution. The process matters. And anything in violation of the Constitution, if you look at the Constitution broadly, any infringement of the Constitution, violation of the Constitution in relation to state officers, including the president, including members of commissions, any infringement of the Constitution normally would attract consequences of removal, impeachment, because it's a matter that this Constitution frowns on. And that's why I always appreciate the fact that this Constitution requires of citizens, every person has an obligation to respect, uphold, and defend this Constitution. This petition is in defense of the Constitution. Is in defense of the Constitution because there's an election that has taken place that is putting somebody in office, or is attempting to put somebody in office without meeting the requirements of the Constitution, not only in terms of, not only quantitatively in terms of votes, but also in terms of what the Constitution requires the conduct of elections to be like. And my learned senior, Mr. Firoz Neroji, referred to a football match. These days, football has many rules, and they keep on improving. However many goals you score, if it is from an offside position, whether you are Messi or Ronaldo, it will not count. It will not count. So I urge the court, and I am an optimist. I think we are doing very well in this republic I think we have come from very far. And as one who has practiced in these courts when things were extremely difficult, I know we are making progress, a lot of progress. There were times to file a petition like this was not easy. And if you file it, serving that petition will be very difficult. And that is not just because of legislation and our new constitution. The courts had made an intervention many times to protect the people against those who govern them, particularly. I therefore invite your lordships that looking at the article dealing with leadership and integrity, what has been placed before you is not a matter that the court can frown on, gloss over. This court said in 2017 in the Raila petition that if the Electoral Commission comes before you with the same kind of infractions and transgressions, this court will not hesitate to take measures against the Commission and its leadership. That is in the Raila judgment of 2017. In 2013, this same Commission, fortunately for the chairperson, he was not there at that time, despite the fact that that petition was not allowed, but the court was not amused by the going-ons in the Electoral Commission. And by dint of the comments that were made by the court at that time, at least a few people were taken to court, although that case is still going on. I think this court, and reading the Supreme Court Act, Section 3, together with Article 259 of the Constitution, which talks to how this Constitution should be interpreted, and more particularly when it says in a manner that promotes the values, the purposes, and principles of this Constitution, and contributes to good governance. So I urge this court, with all the humility, that although this is a petition basically under Article 140, as defenders and protectors of this Constitution, you, with respect, cannot allow what has happened at IBC to go without some kind of action in the lines that was suggested by my learned senior, Firoz Norji. Impunity must be punished. Impunity must be punished. And impunity unpunished breeds arrogance. And arrogance leads to arbitrary exercise of power. And without that being done, this commission, which has got the protection of the Constitution, without the court making some interventions, it still be a divided commission with a triumvirate that runs the affairs of a commission that is supposed to protect and defend the sovereignty of the people. And what I'm saying in a nutshell, that this election cannot pass on account of violation of the Constitution, even by the constitutional dictates how this commission should run its affairs. If they cannot conduct their affairs in the manner dictated by the Constitution, then how can they preside over an election? and that election have some legitimacy to the people of Kenya and to the world. Secondly, and this would be my last point, that if you look at Article 138, sub-article 4, and my learned friend Mr. Otiende addressed you on this, that requirement for a successful candidate getting 50% plus one of the votes cast is not an idle provision in the Constitution. It requires of the Commission to come with it before your Lordship seriously when there is contestation and put the numbers before you in rebuttal to the case that were put before you. My little friend, Mr. Mahat, who is also my very good friend, in his address, he was not talking about what the law requires or what the Constitution requires. He was saying, this is what we do. This is what the Kimskits do. There was no constitutional or legal foundation that he was resting his arguments. And therefore, yeah, my ladies and your lordships, I would ask the court to apply the provisions of the Constitution to the letter holistically and allow this petition and return this country and back to the people who are sovereign, and let a proper choice be made of the person who is going to lead Kenya in the next 5 years.
Your Ladyship, Madam Chief Justice, Your Ladyship, Madam Deputy Chief Justice, Your Ladyship, and my Lords of the Supreme Court. The petition that was filed by the first petitioner, to recap it, was a very simple, by the second petitioner, I think we are the second petitioner as amended, was very limited to a legal issue. It was, what was the position vis-a-vis the election and the role of the commissioners? Now, yesterday, and I think Justice Lenola said something about tweeting and stigmatizing, but in a nice way. When this petitioner came, and I had said it in my opening address, and yesterday Mr. Ngatia said, senior counsel said something very, very, I mean, it's our country. He said, this is one country that even the humble can go to the top. But there was a caveat that seems to have been missed out. If you are a normal, humble person who comes to challenge a presidential election as required by the law, you still get targeted as being a surrogate because that was repeated 3 times. So there seems to be caveats in these things that we don't seem to know about. Yesterday, my lady, Justice Njoki, asked a very direct question. What is the role of these 6 commissioners and the chairman? Because we seem to be getting in a very empirical chairman. This morning, we got absolutely no idea, except the court was taken to Section 11A and B of the IEBC Act. We were told nothing more. From what I can now see is that these 6 commissioners are supposed to be flower girls and page boys at a wedding, with the chairman being the bride or the bridegroom, as the case may be. That surely was not the intention of the Constitution. it appears that that's because I was actually waiting for that answer just as much as your lordship and lordships and ladyship was there was nothing given. Please go to 11A. That's all you were told. We have an umpire, and I'll use it in the cricket term because in football it's called referee. But here in the cricketing terms, it's called an umpire. It is supposed to be an independent umpire. But I heard some I was a bit surprised yesterday when I heard words like shock and awe tactics. And surprisingly, the shock and awe tactics actually came out in one of the protagonists, the ones, the protagonists of We've Won, and that was in one of the affidavits. And these are the direct words that an umpire is using. So how is this umpire as independent as they are claiming to be? That is my client's case, that we need an independent body. The second one, we were told by the umpire, get over it, quote, unquote. We were told by one of the protagonists, move on. If there has been a breach of a constitutional, and as it has been our submission, Article 138, 3C, if there is a breach, do we just move on? That's what we are being told. Forget the transgressions that anybody is doing. Justice Lenola, in the opening day after the petitioners had made some submissions, asked a question which I didn't see anybody answering. He asked a question regarding Regulation 87.3, where he had stated that if it should be struck down, but it's already been done. So, that was the regulation which was in place. If your lordships and your ladyships will look at my submissions, my original submissions we had filed, and we specifically addressed that issue. What is a nullity is a nullity, and I believe it is in the McFoy case, it's an English authority, that we have quoted in our original submissions. So I hope, Justice Lenola, it answers your question.
Thank you.
Because I think nobody here actually took those questions seriously. They didn't answer them. And I don't mean to be disrespectful or being facetious at all. As far as from what I can see is that this, by the law, by Article 138, 3C, it says commission. We were told commission, but it doesn't say commissioners. That was a distinction being made yesterday. It says commissioners, doesn't say commissioners, but commission. With due respect, all those commissioners are appointed, well, not at the same time, but go through the same rigorous process. Does it mean all animals are equal, but some are more equal than others, which means the chairman is more equal than anybody else? These, like I've said, and I repeat again, are just flower girls and page boys. That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show? Surely that cannot be the issue. The other issue that the Chief Justice asked yesterday, why was it not declared to everybody? And that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us that answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into Maina Kiai case, but you were quoted paragraph 287 of the Supreme Court, which I called RILA, which was RILA 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the IEBC, and the chairman, who was the current chairman, for there being no verification by the Commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter, and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. Where it is established that a state officer is subverting the Constitution and the rule of law, the court's hands are not shackled by procedural niceties. This is the beauty of this Wanjiku Constitution that we have. It's transformative, and some people say it's a very overused word. But in these circumstances, it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court. And in closing, whilst we said, we were told our petition is much ado about nothing, and like I said, we've really been battered, but we shall soldier on. I will use Martin Luther King's words because I suppose, unlike Professor Guido Muigai and Mr. James Orengo, I went to a school where they didn't teach us Shakespeare, they taught us Things Fall Apart. They went to the posh schools. And all Martin Luther King said in 1968, at the speech given at the National Cathedral, we shall overcome because the arc of the moral universe is long, but it bends to justice. That's all we request. Can we have justice for all of us, for the voters? Because the two parties just think about themselves. They forget us, who are the voters. Thank you. And I donate my 4 minutes back to the court.
Thank you. We will have the third petitioner, Youth Advocacy Africa, and Peter Kireka.
Madam Chief Justice and Madam Deputy Chief Justice, and may it please the members of the court. Yesterday, and for a section of this morning, Your Ladyship, I believe we've been allocated 30 minutes. I see the clock says 15. The directions clearly said 30 for us. Youth advocacy.
I don't know whether there was any question directed to you.
Yes, there were. But the direction said 30 clearly.
No, the directions I have.
Yes, for youth.
Yes, for youth advocacy is 30 minutes.
30 minutes, yes. I think the clock said 15. Yes. I was a bit concerned, yes. But for yesterday, for most of yesterday and this morning, members of the court.
Sorry, Counsel.
Yes.
For our record.
Yes.
Introduction.
Yes, Your Lordship. My name is Tom Asharia. I appear together with my colleagues on record for Youth Advocacy Africa and Peter Kireka. Most of yesterday and this morning, you are treated to the theory of an election as it ought to be conducted. My colleague, Julie Soweto, has demonstrated to you what every Kenyan knows. Mambo kwa ground ni different. I call your attention to the affidavit yesterday presented by my good and learned friend, Professor Kindiki, which has been projected. It's the affidavit of Veronica Ndwati. She deposed that she is the Secretary General of United Democratic Alliance and was the Deputy Chief Agent for the 9th and 10th respondents. In particular, I call your attention to paragraph 7, where she states that the verification process went through a 3-tier mechanism. At paragraph 7, she says the second tier was at the constituency level where the following actions were undertaken. She then goes to subparagraph C, and that is the one of interest here, and this is what she says. In case of any errors, this is at the constituency level, on Form 34B, the same would be corrected. That is the key. Those are the key words. She then goes on at paragraph 8 and says that the third tier was at the National Tallying Center at Bomas of Kenya, where the following activities took place. We go to paragraph 8F. The verification team would also verify that each of the uploaded Form 34A in the public portal is a replica of the original 34A presented by the constituency returning officer, and in instances of discrepancies, the errors were noted. She then says at G, the team would also verify that the data entered in the IEBC online system for purpose of tallying from all original forms was correct. In case the data entered in the IEBC online system is incorrect, the same was corrected on the online system. She then goes at J, a verified Form 34B would thereafter be generated at Bomas. Another one, having corrected at constituency, another one now is generated at Bomas and supplied to the candidates' agents. I specify these particular provisions because, members of the Honorable Court, this is precisely what the chairman of IBC was told in the minor KI case he could not do. And it bears reading because, as has been repeated here severally, and perhaps I shouldn't repeat it too many times, he is qualified to be a Supreme Court judge. And so we know he understood minor KI. So it is important that we understand what he did not understand about the following passage. It is evident, I'm reading from minor KI, it is evident to us from the above sequence of events that the role of the chairperson of the appellant is circumscribed. Article 138 deals with events at the polling stations where votes are counted, tallied, verified, and declared. The appellant, that's the commission, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president, electronically transmitted to it from near 40,000 police stations, is required to tally and verify the results at the National Tallying Center without, this is the key word, without interfering with the figures and details of the outcome of the vote as received from the County Tallying Center. Minor KI states further, the chairperson, on the other hand, is appointed under Article 250 of the Constitution. The chairperson cannot be and is not the commission. It goes on to say, and I say this because my good friend George Morogo this morning told you that whether the chairman is the commission or the chairman is a matter of context. It is not a matter of context. Minor KI put that debate to rest once and for all. And finally, to suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, then that's the word, correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency tallying centers is to donate an illegitimate power. Such a suggestion would introduce opaqueness. These were the words used by the 4 commissioners who disagreed with what was going on at Bomas. Opaqueness and arbitrariness to the electoral process, the very mischief the Constitution seeks to remedy. I don't know how much clearer it can get that what the chairman of the commission did was the very opposite of what the Constitution required him to do. Now, minor KI was itself based on several decisions of this court. The first of those being Wanjohi, which is a 2014 case, and it is cited there, where the court said, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including the returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of state. The only organ under our constitutional framework permitted to correct at any level, let alone any of the three levels that the chairman of the commission undertook, is this court. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. We reiterate as we conclude that there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one individual, the chairman of the appellants. Now, as we stated, the chairman is an eminent lawyer, qualified to be a Supreme Court judge. It is extremely unlikely he did not understand what Maina Kiai had told him. And the only reason he would then have proceeded in the manner that Veronica Nduati tells us is that, to use another Kenyan phrase, mtadu, what are you going to do about it? That is the only reason one can find for what he did. Yesterday, the commission came and told you that the system was accessed thousands of times by officers at the Bomas. And so clearly, you had returning officers, specific special returning officers, assigned to changing forms on the portal, as has been demonstrated this morning. In our submission, the alterations made to this system, to the forms, these so-called corrections that were done at three levels, so alterated and contaminated the outcome of the election that it is now incurably defective and incapable of being rescued. Now, we were challenged to demonstrate from their own forms what the problem was with the forms. Now, time doesn't permit me to take you directly to those affidavits, but the commission has filed an affidavit through the firm of Iseme Kamau and Maema in our petition, the affidavit of Esther Wanjiku Wanjohi. She attaches 14 forms. That's about a quarter or 30% of the forms that you asked to be taken through the scrutiny. Of those 14 forms, 8, representing 57% of the forms, 8 have irregularities, have gaps, have problems, including the fact that when you read them with a QR code, the serial number that shows up is for a different polling station. The problems are correction problems, tallying problems on those forms submitted by the commissioners themselves, by the commission itself. You have an affidavit submitted again by the commission, the affidavit of Nzika Muololo. Same problems. He has 2 forms. 50% of them, which is 1 form, has an incorrect addition where the rejected votes have been added as part of the total. Now, in light of what Maina Kiai said and what my learned seniors have said here this morning, my mind is taken back to a few months ago when a few of my colleagues here, my good friends here, came before this court and told you and persuaded you that a process known as BBI, one where 1 million signatures had been collected, one which had gone through over 40 county assemblies, one which had gone through both houses of parliament, was irredeemably void and null because the president used the wrong process. And they persuaded you. And I invite you to look at paragraphs 1544, 1535, and 1500 of your judgment in the BBI case, where you stated that any process, any activity undertaken without constitutional authority, as the chairman of the IEBC has done in this particular case, must be declared null and void. And the terms null and void, and this is one of the cases we've stated before you, the case of McFoy versus United Africa Company, is captured in the following words. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have a court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. That is the fate the Form 36, the Form 34D, issued by the chairman of the commission in this matter, must suffer as well. Now, my learned friend, Mr. Mahat, has taken you through some numbers. And as I've demonstrated, and as was demonstrated earlier here by my colleagues for the first petitioner, when you have a process where the numbers are so adulterated, where the forms are so compromised, what numbers are we talking about? Numbers that have been verified or quote-unquote tallied in an unconstitutional matter. Our learned senior, I think Mr. Orengo, I think it was Otinde Amolo Senior Counsel, said that the numbers became a moving target. Now, in fact, they were behaving not more like a moving target, but like a group of naughty children in a nursery school running around the yard. It is impossible to get a hold of the number that was used either for the 50+1 or for the tallying or for the verification, which, as you have heard, was changed 3 times. Now, you asked, I think, of the petitioners, how did we get to this place? Like every slow train crash, a train crash in slow motion, those of us who lived through the repressive days that led to the Constitution of 2010 will tell you that it did not happen one day. My good friend Mr. Morogo has told you that the Gazette notice by which the chairman appointed himself as the presidential returning officer. And we need to note, because the defense put here yesterday by the commission, was that he appointed himself on the basis of your judgment in 2017, where in passing, you said that there is a national returning officer. Now this year, he has upgraded. He upgraded himself to presidential returning officer. Now you've been told that Gazette notice means nothing. And I think yesterday you were told we ought to be grateful to him because he had the good grace to publish in the Gazette his unconstitutional appointment. Now, whether you publish misconduct in the Kenya Gazette or you publish an offense does not imbue you with some sort of value or it does not imbue that process with some good grace or quality if the Constitution does not permit that office to exist or does not permit him to conduct himself in the way he did. A Gazette notice does not improve it. But perhaps more importantly, if it meant nothing, why publish it in the first place? If it meant nothing, why publish it at all if it meant nothing? But the point I wish to make is this. Complaints were raised. I think I've seen letters written by the party that nominated the first petitioner. There were newspaper articles complaining, Gazette notices, newspaper notices complaining that ballots had come without commissioners being told, but you'll get to hear that a bit more. There were complaints made by civil society. But as happened with Kenya, when we ended up in the position we ended up before the 2010 Constitution, we keep pushing these things away to the back of our mind. And people go to campaign, and he publishes a new Gazette. I am now the presidential returning officer. He goes on ahead and does other things, allocates duties. You go look after flowers, you go be at